Record. Dobar den od mene, Silvana Pavlovska i programata Vo Fokus so Silvana Pavlovska. Ova programa se emituje od Melbourne, Avstralija. Inače, ja sam novinar po profesija za onije koji što ne me poznavate ili pak ne ste me slušnale ili gledale dosega. Vo продовжение на ова програма продолжуваме со серијата посветена на македонското прашање и делото на почитуваниот и ценет професор доктор Игор Јанев, насловено The Prespa Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. A book published in 2023. So, for those of you who may not have understood my brief introduction, this is Silvana Pavlovska and In Focus with Silvana Pavlovska, broadcasting on YouTube in English and Macedonian. On this occasion, it's going to be mostly in English. And so we continue with chapter 4. Bear with me for a moment, please. I'm not sure, did I mention today is the 22nd of March, 2024, and wishing you a happy day, all of you, wherever you are on this planet Earth. I am now going to open the publication on my screen so I can look at you and look at the publication instead of putting my head down occasionally to look at the printed copy. So let's see how I go with that. Okay. That's it. 4.3. Okay, stop that share and we're going to I'd like to show you the book. I'd like to show you the printed copy so you can look at it and I will be looking at it and reading it for you. Now, page 157. Let's have a look at page 157. This one we've already covered. You can see here there are lots of links in this PDF file that Professor Dr. Igor Yanev has provided to me. It's important to mention that Professor Igor Yanev has given me permission to put this scholarly piece of work in the public domain. So we're looking for 157, page 157, coming up shortly. Now, whilst I'm looking for this page, I think I'd like to remind you that each week, for the last few weeks, we've been covering this scholarly publication, and the intention is to do so in full. So when you go to my channel, YouTube channel, Silvana Pavlovska, you will be able to have a look at the dates on each title, which will give you an idea when they were done, because they are in the order of dates. As I do them, I include the dates so that it's easy for anyone following this YouTube broadcast to find the information in a particular sequence. Okay, 152, a few more pages. Thank you for your patience with me. You may remember that in this chapter 4, we have been provided with a lot of details, the reasons, the facts, the references to the various, whether they're the European Commission's own publications related to the issues that Professor Dr. Igoryanev is talking about, or whether it's to do with other important documents that he is referring to in this publication, where he's arguing that the Prespa agreement, I'm sure you've gathered by now that the Prespa agreement, that the PA, as it's often referred to, which was signed back in 2017, not that long ago. Nevertheless, it's been implemented by the Macedonian government, which is a real concern by the Macedonian people, as it doesn't trust the government of the day. As we have seen, the benefits are not there. In fact, it's quite the opposite. So the Prespa agreement as cultural genocide is what Dr. Professor Igoryanev is saying. It's a genocide, cultural genocide of the Macedonian national identity. So his arguments are contained in this chapter 4, and it is important to pay particular attention to the information that I'm providing you with. Hopefully we'll get some comments from you. So I am now happy that I have found the section that I want to share with you today. It's the bottom half of this page, 157, and it starts off with, in summarizing the circumstances related to the preposterous identity changes under the Prespa agreement, we need here to give some answers regarding the question how such international, and you can see it's in quotation, problem emerged over the state's name, sometimes called the name issue. And in 1992, the first president of Macedonia, the Republic of Macedonia, after its independence from the breakup of the Federal Republic of Yugoslavia, you may recall, in 1991, despite the opinion of the European Union's Arbitrary Commission on Yugoslavia stating that Slovenia and Macedonia were the only states which satisfied the criteria for statehood, or statehood, I should say, under the strong objections of Greece. Yeah? And its opinion number 6, you can see here, see Greece's objection to the name problem in Greece's Macedonian adventure, the controversy over Fyром's independence and recognition. That Fyrom is definitely still a very derogatory term and certainly not appreciated by the Macedonian people. So coming back to the last sentence, I'll repeat that again. In 1992, the first president of Macedonia, Mr. Kiro Gligorov, despite the opinion of the EU Arbitrary Commission on Yugoslavia stating that Slovenia and Macedonia were the only states satisfying the criteria for statehood under strong objections of Greece, needlessly started to negotiate with other countries, Macedonia in this respect, in 1992 over the name of the state, in brackets of Macedonia, negotiations. And by doing so, naively admitted that there was an issue between the two countries. So here we are, the Macedonian Republic of Macedonia, those who are leaders, government officials, I'm laughing because it's ludicrous. They naively admitted that there was an issue between the two countries. Naively admitting something that's not really the truth. Anyway, that's my commentary. So naively admitted that there was an issue between the two countries. By starting these ridiculous negotiations, says Professor Dr. Igoryanev, over the national name, Gligorov unconsciously confessed that a dispute exists, and therefore he, by implicit admission of so-called difference, in fact, participated in the creation of an issue and a dispute itself, as reflected in the Lisbon Declaration in 1992. So here we have the President of the Republic of Macedonia unconsciously confessing that a dispute exists, because Greece is claiming there's a dispute in the name, and he then agrees that there is a dispute. Yeah, admitting there's a difference. Now, how can this be so? How can this be so is the question that Silvana Pavlovska is asking in this program called In Focus. So the President Gligorov, completely unprepared, came to the UN, and did not understand the legal aspects and or objected to the preposterous imposition of the provisional denomination, the FYROM, in the UN, apparently demonstrating a fundamental lack of knowledge of international law and its basic principles. Furthermore, people surrounding this President Gligorov also didn't know that disputes over the state's name cannot exist between two states under any circumstances. This is in international law. Even if someone understood anything, he could not express an opinion, since Gligorov's vein and his always undisputed opinion that was in autocratic way unquestionable at that time, says Professor Dr. Igoryanev. It should be mentioned that President Gligorov's educational background was a graduate school of law. He did a graduate school of law in Serbia. But despite that educational background, he showed in United Nations surprisingly low capacity to understand the basic principles of law, such as non-interference in domestic jurisdiction and sovereignty. So Professor Dr. Igoryanev now says, I personally came to that conclusion serving as an advisor to the Minister of Foreign Affairs of the Republic of Macedonia in 2002. Shortly after my engagement in the ministry, serving as an expert on a name issue, I learned that from the time of the presidency of Kiro Gligorov, it has been informally forbidden to use the term negotiations, since Macedonian government never internally admitted that they were in negotiation mode with Greece. They never did. And with regard to that, diplomats were informally instructed to use the terms talks or discussions instead of negotiations. Amazing, isn't it? So already the truth has been twisted. Yeah, they never internally admitted that they were actually negotiating with Greece, and the diplomats were not informed of the truth. They were told to use other words like talks or discussions. Well, talks and discussions are not negotiations, are they? That was, so my question is why? Why was that so? Why did they do so? What did they have to hide? That was surprisingly naive interpretation by the Macedonian government, since in the interim accord with Greece signed in 1995, Macedonia explicitly agreed to negotiate with Greece. So my commentary now, please forgive me, listener, but this is the Macedonian government. When they signed this so-called interim accord with Greece in 1995, they actually explicitly agreed to, in quotes, negotiate with Greece in the text of that treaty. So it goes back to 1995. It's been going on for many years before the signing of that Prespa agreement, obviously. Second, there was unofficial request that diplomats do not ever use short or abbreviated form, the FYROM. Instead, the unabbreviated normal reference that is the former Yugoslav Republic of Macedonia. What was embarrassing for President Gligorov and the others in his administration and after his presidency was an ugly abbreviation, the FYROM, as his legacy, MFA, accepted that diplomats must always use the former Yugoslav Republic of Macedonia as less or not humiliated form of so-called reference. Now, here, I, as a journalist, having quite a lot of knowledge and insight into this, also wish to point out that this term, firearm, was also used by the Australian authorities. They very quickly changed all data related to the Republic of Macedonia to firearm, much to the discontent and the protests by the Macedonian community in Australia, which is of some significance because of its population numbers. Right, continuing on from here, let's see what Professor Dr. Igor Yanev says. What was embarrassing for Gligorovs and others in his administration and after his presidency was an ugly abbreviation, the firearm. So as his legacy, MFA accepted that diplomats must always use the former Yugoslav Republic of Macedonia as less or not humiliated form of so-called reference. Remarkably and most surprisingly, MFA also informally requested that all Macedonian diplomats never use the term dispute. Dispute is in quotation. Ministry of Foreign Affairs, MFA, informally requested that all Macedonian diplomats never use the term dispute instead of difference. Although all foreign diplomats and international subjects usually use the term dispute, including official documents, which as a term is more accurately describe the problem between the two countries. What was surprising for me, says Professor Dr. Igor Yanev, who is the author of this publication, which I'm sharing with you, the title being the Prespa Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. What was surprising for me in contact with many politicians was that they were not ready to accept the term denomination for imposed description, the former Yugoslav Republic of Macedonia, and usually corrected me, they corrected the professor, corrected me by the term reference or provisional reference, temporary reference, like they were trying to hide something or the true nature of illegal reference to firearm. All in all, Professor Igor Yanev says, I came to the conclusion that in time, or at the time of admission to the UN in 1993, President Gligorov didn't know that the Greek demands do not have a legal basis in law. He did not know. And that particularly included an allegation related irredentism, as was later rejected by the ICJ judgment 2011. In fact, Gligorov acted as Macedonian state was guilty for its national name. So he acted as if the Macedonian state really was to be blamed or was guilty for using its national name. Second, Macedonian representatives, advisors of the President Gligorov in the United Nations in 1993, didn't know that 2 additional conditions for admission to the UN were also imposed and were also illegal, and that one of such condition was a denomination, the firearm. That is, most fundamentally, they didn't know that there couldn't exist disputes or differences between the 2 or more states about the state's name. Third, Kiro Gligorov, the president of the Republic of Macedonia at the time, and his administration, most importantly, did not know and realized that states may not have an exclusive right over the name of the state, and that from a legal point of view, with respect to that, the state's name, 1, cannot be imposed or deprived, 2, cannot be subject to theft, 3, cannot be subject to negotiation or contract or impositions by other external instruments. 4, Gligorov didn't know and did not comprehend that a change of the name of a state does not result in the change of its rights or duties regarding the other state's territory. nor have any relevant implication on its own history or a history of some other state, writes Professor Dr. Igor Yanev. Furthermore, Gligorov appeared that he did not comprehend the relevance of similarity of the state's name, Republic of Macedonia, with the name of the 3 Greek administrative regions that do not preclude or impact international right to call the state by that particular name, since in the case of the Republic of Macedonia, it is a name of the subject of international law, while in the case of the Greek provinces, their names designate subjects of internal law, not subjects of the international law. You may remember in my previous broadcast, I read you the information from Professor Dr. Igor Yanev as to what Greece had done in creating these, internal, within the borders of Greece, provinces using the name Macedonia, making reference to Western, to this or that. Yeah. Coming back to this, in conclusion, the president of Macedonia didn't have enough diplomatic knowledge and especially knowledge of international law, so Macedonia became the first nameless state ever admitted in the UN. A state without a name being admitted by the United Nations? How so? How can this be so? Not to be too critical of the President Gligorov, other Macedonian presidents and prime ministers also didn't understand the basics of international law and continued to negotiate with the other country, other being Greece or the Hellenic Republic, the change of the state's name, naively believing that one day a solution to the name issue will only be for external use. And that domestically Republic of Macedonia will remain in the national constitution and domestic legal order. I mean, this is incredible. I don't know what you think about this, but how can somebody who's been entrusted to be the president or the prime ministers of the Republic of Macedonia or any country or state in this world, how can they believe something that is not based on facts? They didn't have the information. They don't know international law. What does it take for people to get them to inform themselves or get their advisors to give them informed facts and truth and figures, what have you, going unprepared and negotiating a name when this is an absolute no. So forgive me, I'm getting a little bit excited. I wasn't going to make commentaries, but I cannot help myself. And I'm showing you this document, which is I document. It's part of a publication from Professor Dr. Igor Yanev, scholarly piece of material based on facts and the truth. And I find it incredibly unbelievable that, people representing the Republic of Macedonia would engage in these activities and agree with Greece on aspects that were really clearly not true. And there was no issue. There was no dispute over a name or anything like that. And so Professor is telling us here what are the legal, reasons for it. So I thought that the name Republic of Macedonia will be used in, internally within the borders of Macedonia, that it won't be extended outside Macedonia and it won't be changed in the constitution and the domestic legal order. Well, we now know in 2024, March the 22nd, that all of that thinking or belief was not based on any facts or truth. And what is more concerning is they never did any research, did not inform themselves, and were representing the people of Macedonia, the Macedonians, and all the other minorities residing in the Republic of Macedonia. A real worry. That assumption proved to be wrong in practice. State of the name had to be changed both for domestic constitutional order and for external and foreign relations. That is the erga omnes. Generally, observing, we may derive a conclusion covering long period of time for all Macedonian governments and presidents that didn't realize and foresee such final outcomes of the erga omnes nature until 2018, when the Prespa agreement was concluded, leaving a dream that state's name transformation process will end only with a changed ID for external use. Very immature, ill-informed. And when that would happen with presumed changed ID for external use only, they believe that Macedonians will live a better, more prosperous life in the EU. Well, that's proven wrong, hasn't it? The country is on its knees in every aspect, politically, economically, culturally. Professor Igoryanev says, in my comment on the illegality of the Prespa agreement for Daily New Macedonia in July 2021, Daily New Macedonia is a publication. In July 2021, I have explained at that time of the state that the state is an essential and indispensable element of both internal and international judicial personality, and that this name as an ID cannot be different in the internal legal order. I explained my position in the Macedonian Daily New Macedonia under the title, so this is another publication, New Macedonia, Nova Macedonia, under the title, quotation, most important international rules and principles related Prespa agreement were broken, especially translated from New Macedonia. 1, the right to self-determination and self-identification of the peoples and of nations, UN Charter, Article 1 and Article 55, including the right of non-discrimination among them on any grounds. 2, the right to possess and to self-determine the state's legal identity as the right to self-determination of the state as a subject of international law. UN Charter, Article 1 and jus cogens on the legal identity of states, since every state as a person needs and has a right to an ID. Number 3, the right to sovereign equality and legal equality of the state in the UN membership and outside of the UN system of organizations. UN Charter, Article 2, Paragraph 1, as a ground for equal legal status, treatment, and non-discrimination. 4, the right to political independence and the right of the state not to be dependent in any way on another state or international organization. This is in the UN Charter, Article 2, Paragraph 4. 5, states' right to non-interference by another state, in this case, the Hellenic Republic, states' right to non-interference by the Hellenic Republic or international organization in matters that are stricto sensu, internal jurisdiction of the state. Again, in the UN Charter, Article 2, Paragraph 7 this time. Number 6, the right to non-discrimination in the membership status and toward the UN organization as a distinct legal subject or person and any organization in the UN system. This is from the Vienna Convention of 1975. 7, the right to equal, sovereign, and independent culture and the inviolability of cultural and national identity. Mexico, UNESCO Declaration of 1982, with due respect for different views and beliefs as a right to different beliefs. 8, the right to equality in cultural cooperation. UNESCO Declaration of 1966, with due respect for different views, beliefs, and cultural memories or interpretations. Number 9, the principle of non-retroactive regulation of the past or historical events by dispositive law, including contracts, and prohibition of damnatio memoriae, jus cogens, and imposition or deletion of cultural views and beliefs and any other form of assimilation. 10, the right to non-discrimination in membership in the UN. This is the advisory opinion of the ICJ of 1948 and the resolution of the General Assembly of 1948, and the right to unconditional admission to universal international organization. 11, the right to independent choice of the state's national name and the national flag in the UN as membership rights and a right to change. Change any of these national symbols is regulated by internal rules of the United Nations. Number 12, the right to non-derogation and non-violability of the legal personality of states vis-a-vis the UN as an independent international legal entity, Convention on the Privileges and Immunities of the UN, and rights of the UN as an unsovereign legal person. 13, the right of inviolability of the basic national symbols to the member states in the UN and related organizations. The name, the flag, the coat of arms, and the anthem, internal rules of the UN. 14, the right to independence and equal rights provided in the UN Charter, where, in addition to the articles of the UN itself appears as a contradicting party to the UN Charter with a full judicial capacity. 15, the inherent original right to an independent choice of the people's own self-identification as a primary right, jus cogens, and the right to collective nationality, jus cogens, by own self-identification in the process of self-determination of nation and people. Accordingly, I concluded that text that Macedonia, after the entrance into force of the so-called Prespa agreement, has been put in a subordinate, legally dependent, that is, position vis-a-vis Hellenic state and based on international law with respect to non-discrimination and in violation of the set of jus cogens norms and domestic constitutional law. Therefore, Macedonia has a sovereign right unilaterally to terminate the discriminative Prespa agreement with a diplomatic note to the Hellenic state that is called a termination statement based on ultra vires violations, and after that, to inform the United Nations regarding Macedonian unilateral act. In other of my articles, says Professor Igor Yanev, recently published in New Macedonia, I gave some explanations of the link or the relationship between the name of the state and the name of the people or a nation, that is the national name. Shortly, since the term Macedonian as the common nominator container is after PA banned erga omnes, second, available derivation from the name of the national state and applicable for everyone using the erga omnes outside Macedonia. In order not to violate the erga omnes restriction, would only be a North Macedonian people's designation, first derivation from North Macedonia. That artificial designation would be in line as prescribed by the PA, the Prespa agreement, and the erga omnes rule implemented even in the UN. So at the end of the process, we noted that Greece and Macedonia signatures and ratification, that is its consent given or approval given, succeeded with the strategy of the Macedonian universal non-recognition as a nation. And without Macedonian consent, that would not be possible. Well, all problem of the name issue from the start, from 1992 to 1993, was that it was not a dispute. It was not a dispute, but one-sided unacceptance or diplomatic non-recognition by one member state of the UN, namely the Hellenic state. If Macedonia didn't accept the provisional denomination and instituted through other member states of the UNGA an advisory opinion from the ICJ, today we may probably have a member state under the name of Republic of Macedonia. Agreement that was created in 2008, that was the Prespa agreement, didn't solve the dispute, but rather, well, it didn't solve the dispute, although they claimed it's going to solve the dispute, but it didn't, but rather produced universal denial and delegitimization or non-recognition of Macedonians, since under the Prespa agreement, that name with Macedonian consent. This is the Macedonians' consent. The politicians' consent now belong exclusively to Greece and the Greek state, and not to former Macedonia or Macedonians. But that is not the end of the story. Further, as a step number 2 in the process of ID transformation, Professor Dr. Igor Yanev says, I predicted that in these processes we'll enter or we will see the emergence of the Bulgarian government with their policy to equalize and transform a new term, North Macedonians, as into Bulgarians only. So for establishing that strategy by using similar methodology as the Greeks and creating a phony dispute, the Bulgarians will, with Macedonian consent, again, you know, the politicians, to next Bulgarian agreement or annex, transform or equalize the language and history of North Macedonia as non-existent, since North Macedonian culture never did exist, did it? Never did exist with Bulgarian one. Naturally, Macedonian identity will be labeled as artificial, and since no other exists, in 2 decades or maximum next generation, people, or rather North Macedonians, will naturally accept that all previous Macedonians have had Bulgarian roots and that they were always Bulgarian. Anyway, I think that'll do for the time being. There's a lot to think about, a lot to ponder of what Dr. Professor Igor Yanev has told us here. So I'll let you do that, and you're welcome to re-listen certain parts of this today's broadcast or any other broadcast. So we've now reached the stage where we are on page 164. So we are progressing well, and I thank you for your attention. Thank you for your patience. This is an important document which I felt was of vital significance that we broadcasted in the English language, so that more people are able to be familiar with what is the background of this whole thing that's been going on for a number of years, and how detrimental it's been to the Macedonian people. So reminding ourselves again, you've been listening to In Focus with Silvana Pavlovska from Melbourne, Australia. And we are covering the scholarly publication titled The Prespa Agreement as Cultural Genocide of the Macedonian National Identity towards the Termination of an Illegal Treaty by Professor Dr. Igor Yanev, an expert on international law, a former advisor to the Ministry of Foreign Affairs during the Kiro Gligorov's presidency, a man with lots of knowledge, expertise, insight, and also an author of many, many books related to international law. So thank you once again for listening to this broadcast, and I'm looking forward to seeing you in the next few days, where we will no doubt reveal more truths and facts. And this is a perfect time now for these things to surface, I should say, and for us to be able to utilize this information in whatever ways we can, so that there is a resolution to this phony or concocted so-called dispute. Now, you might have gathered my background is Macedonian. Yes, indeed, a proud person of Macedonian background, an Australian as well, of course, but the roots are Macedonian, and we have a lot to be proud of, but we are not indeed proud with the way some foreign countries have, including the United Nations and other organizations, have actually treated Macedonia, consequences of which we are still enduring. Thanks again, and bye for now.